Hello again, everyone. I'm Zachary Lawrence. On December the 14th,
You got it.
2017, I'm here with my friend, mentor, and eviction expert, Dennis Block. Dennis, give me a fist bump to start the podcast. Thank you very much, sir. And this is the podcast where landlords can tune in free on Dennis's website at evict123.com and listen in on what I think is an interesting discussion on the realities of landlord-tenant law. Dennis, do I have that right?
I think you got it real good, but I wanted to make an announcement.
The camera's right there, sir.
And the announcement is we have now moved into a new territory. We will now be accepting evictions in the county of San Diego.
San Diego
So if
County.
any of you guys out there have property in San Diego, we are now set up to do actions in that county. And that county actually has something that's somewhat unusual. It has what they call e-filing, so that documents can be filed literally in 3 minutes, regardless of where we are in the state of California. So it does make for efficient processing of documents. San Diego is really ahead of the curve, somewhat like Orange County, and unlike Los Angeles County or Riverside or San Bernardino. We can do e-filings once again in San Diego and Orange County, so it's going to be a new territory for us. And if you do got property there, you're going to get the same exact service that you're used to.
Okay, so Dennis is now available to throw your tenants out in San Diego, as far south as San Diego. And where does the long arm of the Dennis Block law firm reach from what point south to what point north?
Well, we go up to Ventura County. We've been doing that for many years.
Have the fires in the state of California in any way had an impact on your business?
No, not at all. Obviously some tenants have gotten displaced, but it's a
Talk about that. If a tenant is in a building, you have a practical experience with it, so go ahead.
Well, I mean, if a tenant is in the building and the building burns down, obviously that's going to terminate the tenancy. If the tenant was, for example, I actually took a phone call on this today. The client was asking me that the tenant obviously couldn't go to work because of the issues dealing with the fire, and they wanted to know whether the landlord had to pay any kind of compensation. And the answer is no. The fact that they couldn't go to work or they couldn't go back to their premises, because not necessarily that they were burned down, but they were just in an area where it was closed off. That doesn't mean that the landlord now has to give compensation because the tenant couldn't get back to their residence, to the apartment house.
So what is the tenant that no longer has an apartment to do?
Well, if the premise is burned down, then destruction.
Or if it's uninhabitable due to an act of God.
Right. I mean, if the premises are destroyed, then that terminates the tenancy, and the tenant is free to pick his life up and go someplace else. There's nothing else the landlord can do in that situation, obviously.
There's no liability on the part of the landlord. Let's say the tenant says, my computer is gone, my stereo is gone, my iPad is gone, my dog was killed, and I have no place to live. The landlord just says, hasta la vista?
Right. Well, the landlord is not the savior of the world. The landlord provides a service, that is accommodations, but that doesn't mean that because there is a fire in the area that the landlord is now this person's benefactor, where he will have to compensate him. So if the premises are uninhabitable, then that's just on the tenant's loss. No rent obviously would have to be paid, and the tenant has to make his own arrangements. That's why we always recommend for tenants to carry renter's insurance, because it would actually cover the tenant's displacement. They'd cover for lodging and food, etc., while they couldn't get back to their property. So for any tenants listening, please get renter's insurance. Also, I suggest, and I know it's in my rental agreement, that you should have a provision in your rental agreement, landlords, that require the tenants to have renter's insurance, just for this eventuality of some catastrophe happening in your area. So it's always a good idea.
Okay, Dennis. So you're basically saying that if the unit is no longer habitable because of the fires that we're going through, and by habitable I mean like not necessarily the building burning down, but there's smoke in the unit. It's not comfortable for the tenant to remain there. And some of his personal property has been damaged, and the tenant doesn't happen to have renter's insurance. Does the tenant have no recourse whatsoever with the landlord?
Again, the landlord didn't do anything wrong. This is just his building just happened to be in the wrong area. So in that situation, obviously the obligation to pay rent would cease, but the tenant is responsible for taking care of his own issues and his own family, his own accommodations. And again, that's why I'm recommending having renter's insurance, but there's no legal obligation imposed on the landlord in that type of situation.
Well, you see, Mr. Landlord, hypothetical, of course, when the fire started and my property became uninhabitable, the smoke alarm did not go off. There was no sprinkler system in the building, and now all my personal property is damaged. Mr. Landlord, would you respond to that, please?
Well, the fact that there's no sprinkler in the building, if there's no sprinkler, that just means there was not a building code which required that. Again, that has nothing to do with the landlord. I'm not sure on what basis the smoke detector didn't go off. Did the battery just go out? Usually they're going to chirp, so maybe that's the tenant's own negligence with regard to that.
Wait a minute. Whose responsibility is it to maintain the smoke alarm?
It is the landlord's responsibility to maintain the smoke alarm, and that's why, of course, the new law requires that you put a 10-year battery in them, but that's only for new smoke detectors, not for older ones. Mm-hmm. But again, it's kind of like the situation where we've talked before where Ralph's Market, for example, has a duty to police the aisles to make sure that there's nothing slippery on the floor. And if a person whose customer is walking down an aisle and slips on a banana peel, is Ralph's Market responsible? And the answer is maybe not. If that banana peel just fell out of a kid's hand 1 second ago and then you walked by and slipped on it, that wouldn't be the Ralph's Market's responsibility. Maybe they're charged with going by each aisle every 15 minutes, maybe 20 minutes, maybe 30 minutes to check to see, but not second to second, where as it's falling, they're supposed to be there to catch it. So, and I appreciate you getting that phone off.
No, I'm going to hang up on him. Go ahead.
Well, that's nice. Just
That was my cell phone, folks, and I am hanging up on the person that just called. Go ahead, Dennis.
Really? Why don't you take the phone call?
Because it would be rude to our listeners.
You think?
I do think. Go ahead.
Okay. So in this respect, when did that smoke alarm go out? How often has the landlord inspected that smoke alarm? And by the way, if there's a raging fire, the smoke alarm doesn't protect the personal property per se. It saves people's lives by able to get out with their own lives, and which happened in that situation.
So if the smoke alarm was working properly, assuming that it was working properly and did not go off, the landlord's duty has been satisfied.
Yes.
And if there's no sprinkler system in the building because the code doesn't require it, the landlord owed no duty to the tenant.
That is accurate.
Okay. Dennis, I want to shift gears here for a minute and show our viewers in TV land this picture of a 95-year-old woman. Let me see if I can get this close enough for them to see. This is in today's New York Post, folks. 95-year-old woman evicted from her Florida home for failure to pay rent. The police came, they cuffed her, arrested her for trespassing, and now she's in jail. Notice the orange prison jumpsuit. And she's being held on $500 bond. Dennis, what's wrong with this picture? Figuratively and literally, what's wrong with it?
And I'm sorry, you said this was in which state, please?
Florida.
Okay, well, I can tell you that wouldn't happen in the state of California. There is a multitude of protections that would prevent this from happening. But obviously, it's wrong. You're putting someone in jail because they refuse to move out of their house. I can only relate it to what would occur in California if you had an elderly person that was being evicted from the property.
And you've done this type of eviction.
Without question. You might have somebody who's infirmed and in bed or is blind, and the sheriff will get there to do the lockout. You've gone through the whole procedure.
You've evicted blind people?
I'm sure I've evicted every type of people, including your people. A few of your relatives, I'm sure I've evicted. But we won't get into that.
And you didn't charge for it either.
No, it was actually my pleasure. But then again, you were the landlord.
That's right.
Why would you evict your own mother?
Unbelievable, folks.
So, but anyway, if the sheriff got there in California, or at least certainly in LA County, and it was an infirmed person, they would back off. They would just not do the eviction. And what they would do is they would call social services to schedule to come out there, and then they would pick them up, and they would be put into some facility because they don't want to throw an infirmed person out onto the street. So that's how it happens here. In fact, on the sheriff instructions, when we, and this is relatively new within the last couple of years, when you submit a writ to the sheriff's office, that's the court order to do the eviction, you have to, it accompanies sheriff instructions. On those instructions, you have to state whether you know if anybody's infirmed, if anybody is handicapped. So this way the sheriff will have a warning of what they're going to come into, and maybe they'll already schedule social services to come to assist in the eviction process. I might add, as an aside, is they also want to know, and God bless them for asking this question too, is do you know if your tenant has any guns or any illegal contraband inside the premises? They also ask that question too. So when we fill out these forms, we do ask our clients whether in fact any of these items are true, so that we'll give a heads up to the sheriff's office. But again, if someone shows up at a property, not only are they not going to put them in jail and drag them out, they're going to let them stay there until they get Department of Social Services to come to assist this person who's obviously handicapped or infirmed.
Why not eliminate the middleman? If the sheriff is not going to throw them out knowing that they're infirm, why not just go directly to social services?
Well, social services has no legal basis of picking somebody out of a unit and taking them away. However, in this situation, they're under a court order, and that's why you need the sheriff there to enforce the court order, and you'll need social services there as a safety net to make sure that they're okay.
Okay, so let me get this straight. A 95-year-old person hasn't paid their rent. They were served with a 3-day notice. The 3-day period has expired. You file the necessary paperwork. The sheriff arrives. He knocks on the door with the instructions that your office has stated that the resident is infirm. Okay, you're the sheriff, you just knocked on the door. Give me the verbiage that would be spoken to this elderly person.
Well, I mean, if we've already given them the information that the person's infirmed or handicapped, then the sheriff is going to come with Department of Social Services.
Oh, they come at the same time.
Right.
Okay, okay.
But let's pretend we didn't know, which can happen probably more times than not.
How could you not know that?
Because the landlord doesn't clue us in. So we submit the paperwork, we have no knowledge, the landlord doesn't say anything to us. So the sheriff gets there and you're really dealing with a 95-year-old person, or you're dealing with a blind person. And it is unfortunate, but let's not lose the forest for the trees, which is this is not the landlord's responsibility to take care of 95-year-old people or infirm people. This is for their family or social services to take care of this. The landlord rented the premises out for rent, and that was the basis upon which he bought the property in the first place. So once the sheriff gets there, if in fact he's not warned in advance that there could be harm done, and that's what the issue is, harm done to the person who's being evicted, they will back off, to the chagrin of my clients, of course, and they will reschedule the Department of Social Services to assist them in evicting this person.
So okay, we're back to my hypothetical. The sheriff and social services are both physically at the door. Knock, knock. Miss 95-year-old, elderly, bedridden, blind woman. Fill in the blanks for me.
Well, obviously, they will assist in removing her from the...
Physically remove her.
Yes.
Physically remove her.
Physically remove her.
Okay, but she's bedridden.
Well, if she's bedridden, then they would put her on some sort of a gurney or something, and then they would probably be taking her to some hospital facility.
Okay. Okay. Now, the status, once that happens, the status of that unit with all of her oxygen tanks and walkers and 24/7 caretaker is what, legally?
Well, the personal property still belongs to the tenant, and but the tenant does have 15 days under the law to retrieve their
A
belongings.
95-year-old bedridden woman is going to move oxygen tanks?
I'm telling you what the law is.
And I appreciate that, but what
You're
is
going to be for the practical?
I'm asking, of course I'm asking for the practical. I understand that.
Well, I'm a lawyer. I talk law.
Okay, very good. Now talk practical law.
Well, in that situation, obviously,
we
the
agree on
landlords-
nothing, folks.
I like your glasses.
Thank you
though.
very much. I appreciate that. Okay, so 95-year-old woman.
So what I'm sure what the landlord would do in that situation is they would gather up the belongings and put them into
Who's they?
the landlord.
The landlord.
Or the landlord's agent. The sheriff doesn't remove any belongings.
Okay.
The sheriff only puts the tenant on the outside of the door. So I'm sure the landlord would gather up the belongings, put them into some locked storage area, and give the tenant a chance to get their stuff back. The law requires 15 days. Technically, if they don't get it within 15 days, if the belongings are, just said technically, if the belongings, gotta watch what you say with this guy.
You do, because I listen.
Thank you. Well, finally he listens. You never listen as a client. But they've got 15 days. Technically, at the end of the 15 days, if the stuff is worth less than $700, the landlord, under the laws dealing with abandoned personal property, can dispose of those items. If the property is worth $700 or more, then technically the landlord has to hold a public auction, and then any funds from that public auction, after the expenses of the auction are taken care of, supposed to go back to the tenant.
Are you telling me that a landlord is going to stand on a sidewalk with oxygen tanks and wheelchairs holding a public auction? Is that what you're saying?
I'm saying that's what the law would require.
But from a practical standpoint, what is he supposed to do?
Well, he can hang on to those belongings until time memorial. But if he does want to get rid of it, and if the person is not coming back for this stuff for whatever reason, then he does have to hold an auction. That's what the law requires.
Okay, so basically there are laws in place which offset the rigidity of an eviction, in which the sheriff would normally just knock on the door, physically remove the tenant, and surrender its possession to the landlord. But in this particular case, the sheriff would be accompanied by someone from the Department of Social Services, and together they would physically remove.
That is correct, and she'd probably go to some hospital facility based on her condition.
Mm-hmm. Okay, now, what if the elderly tenant is there with a caretaker, and the caretaker, Dennis, says to the sheriff, you know, she is not to be moved. Here are the doctor's orders. This woman is not to be moved because, Mr. Sheriff and Mr. Social Services guy, if you move her, you might kill her.
Well, I would think that in that situation with a doctor's note, I think they would back off, but then social services would do their own evaluation of what it would take to remove her. Obviously,
so they wouldn't take, under those circumstances, they would not move her.
I think they would do a further evaluation. However, let's think this out logically. If the person's having a heart attack, then what's the first thing you're going to do? You're going to take that person to the hospital.
No.
So to say that they can't remove her, and by removing her, she's going to die, I think
movement. I'm talking about the physical act of movement may not be medically.
So she can never go to a hospital. She could
well,
never
that's why she's bedridden. She's bedridden.
But if she's having a heart attack, they're supposed to
Nobody
perform
said
the
she's
surgery.
having a heart attack.
I think your premise is a little bit
Okay,
off.
okay, so
but let
basically,
me tell you something else.
So basically, no. What you're saying is that if the caretaker, okay, I know you're trying to make this a frivolous thing, but what you're saying legally, okay, and for the record, okay, is that if a elderly woman is being evicted with the sheriff and the social services present, and the 24/7 caretaker shows the sheriff a document signed by the elderly woman's doctor saying this woman is not to be moved.
In that situation, I think I've explained this, that social services would do their own evaluation. I can't imagine that would be followed, that the person could never be moved. But again,
I didn't say never be moved. I said in that moment in time when they go to the unit and they're given that information.
Okay, they're not going to remove somebody if somebody is going to die as a result of that, or become much more injured as of a course of that. But again, social services would review it themselves. But you know, on that same vein, I want to talk about
You want to change the subject, don't you?
Well, I think,
Okay,
we've already done 19
okay,
minutes on this
fine,
lousy
we've exhausted
topic.
the subject. Okay, let me ask you this, Dennis. Here,
I can't move on
okay,
to it.
well, go ahead. Go ahead.
What we get a lot of times is in the same situation, you have a caretaker and you have an elderly person who's obviously being taken care of. And what happens is the elderly person either dies or is moved to a facility and never to come back. And what we've been seeing a lot of is that even though the caretaker was not a tenant, was only there as a result of their employment with the elderly people, they refuse to move.
The caretaker.
The caretaker refuses to move. So in that situation, we're forced to do an eviction. We're doing a couple right now. The law requires, in that situation, even if it's under rent control, that we serve on this person who's not our tenant and was just there at the behest of the elderly tenant, that we serve on them a 3-day notice to quit. That this person is an unauthorized subtenant at the end of the lease term.
A 3-day notice applies to those that are not tenants?
That is correct. So it's going to be a 3-day notice.
I just learned something.
Yes.
I thought 3-day notices were only applicable for tenants that are living in the unit.
Right. In this situation, they're considered an unauthorized subtenant under the law. So they're served with a 3-day notice to quit, and then we proceed forward with an eviction. I have one case that's going on now which is so abusive, and in this particular case, and I hope the other side is watching, is that there was a tenant, wasn't infirmed, but he illegally sub-rented the unit to 2 other people. He had a trouble with them, said to the landlord, "I'm sorry, I'm leaving, and I know you've never taken rent from these people, but do what you need to do to get rid of them." Well, we started an eviction based on that same unauthorized subtenant with a 3-day notice to quit. And the attorney on the other side, if you know what the term chutzpah means, but it does mean...
Do I look like I know what the word chutzpah means?
Yeah, you do.
Thank you.
Anyway, it means the nerve. Not only is contending that they are lawful tenants there and paid the rent, even though no rent was paid, he's now filed a lawsuit against the landlord for breach of the warranty of habitability, even though my client has never been his tenant. So we see a lot of that. So
the unauthorized tenant is suing the landlord for a breach of habitability,
even though they're not tenants.
but he has no standing to sue.
Well, anybody can sue.
Anybody can sue anybody. Okay.
You got it. So that case is actually going to court. They tried to delay our case with the other case, but it is going to court in the next couple of days. Maybe I'll mention on the next podcast as to what happened.
Okay. So the lesson here is that you may serve a 3-day notice, which is binding on anyone in that unit. It doesn't even have to be a person on the lease.
Well, this is an unusual. Normally, when you're terminating a tenancy, a month-to-month tenancy, you're going to serve a 30-day notice or a 60-day notice. There are some circumstances where you can serve a 3-day notice on your tenant. For example, nuisance activity. If it rises to that, it would be a 3-day notice to quit. For example, a guy shooting up the common areas with a gun. That would be a nuisance, and you'd serve a 3-day notice to quit. But sometimes the tenant vacates the premises, leaving strangers behind. In that situation, the same notice would apply. It would be a 3-day notice to quit.
So the moral of this story is, landlords, if you're listening, if you have an unauthorized tenant, do not hesitate to use the 3-day notice, because it has the same legal teeth, if you will, of towards an unauthorized occupant as it would a tenant named on the lease.
That is true, but these are non-standard forms, so these types of forms, when you get into this type of a situation, really need to be handled by an attorney.
Okay, how is that form that we're talking about, serving a 3-day notice to an unauthorized tenant, different than the form with an authorized tenant? How is the form the same?
No, the form would be different. One, as I mentioned, would be for nuisance behavior, so you'd have to be quoting different code sections.
No, I'm talking about the form on your website. It says free forms, download here a 3-day notice to perform or
Okay,
quit.
there is no 3-day notice to quit on my website at all. There is a 3-day notice to pay rent or quit. There is a 3-day notice to perform or quit,
That's
but
what I just said.
there's no 3-day notice to quit on my website, because that's more of a hybrid form. and it really has to be determined whether it's
Okay.
proper or not.
Let's cut to the chase. If a landlord has an unauthorized tenant and he wants to serve them a document, which document is that document on your website?
No.
No. Okay, so you have to call your lawyer, and it is a specific document for that scenario.
That has to be drafted almost personally for that situation.
Okay, fine, thank you. Moving right along, Dennis. Here we are in December. Christmas presents are due. I'm still waiting for yours, but I've been waiting for 20 years. But that's
And you're
another
gonna keep
story.
waiting,
And I'm going
I
to keep
might add.
waiting for it. Do you find that in the month of December, people don't pay their rent because they've made other financial commitments?
We have the same amount of evictions in December as we do in any other month.
Okay.
It stays pretty consistent. The only thing in December that we notice is that the court personnel clerks seem to slow down on their work. The sheriff seems to be reticent to do evictions right around Christmas time, so they'll be delayed until after Christmas. So
Does anybody ever get evicted on Christmas Day?
well, since Christmas Day is a legal holiday, the sheriff doesn't work on legal
Doesn't work
holidays.
on, okay, all right. So Christmas Day, you can't get evicted. New Year's Day, you can't get evicted.
Or Saturday, Sunday.
4th of July, you can't get evicted.
Yeah, no legal holiday.
Saturday and Sunday's not a legal holiday.
But they are under the code.
Under the code they are.
Yes.
Okay. What about Yom Kippur? Is that can you be evicted on Yom Kippur?
Yes, you can.
Well,
It's not considered a legal holiday.
Well, if you're an Orthodox Jew, that's about as big a holiday as you can get. So you're saying that the law does not acknowledge all religions, only Christmas? What other religious holidays does it acknowledge as a...
Whatever the major holidays are.
Okay, all right. Okay, Dennis, we are approaching January the 1st, and in the few minutes we have left, January 1st marks the day when marijuana will be legal in California.
Oh my God.
Not just for
Are you
medical...
cleaning out your pipes?
Yeah, I am. Not just for medical purposes, but for retail purposes. I mean, you can be, starting January 1st, somebody in the state of California that lives here can go to a store, just like they would go to, Adidas shop, buy some pot.
Up to 1 ounce.
Up to 1 ounce, so he knows the law. Go ahead. So in what way, shape, or form, if any, does this impact the landlord-tenant relationship? I just came back, meaning the tenant, from a store. I bought some joints, and now I'm going to smoke it on my balcony. I'm going to smoke it inside my unit.
Knock yourself out. However, every landlord should have in their rental agreements a no smoking provision.
Does it specifically have to say marijuana?
No, smoking is smoking.
Smoking is smoking.
So, and I would recommend that you have that. I know that I have that in my rental agreement, which once again on my website, evict123.com. But you should have that in there because obviously smoke bothers other people. And also I think it's difficult when you're renting out units if someone is smelling either cigarette smoke or marijuana smoke. Now, it's interesting that with this new law, you're going to see so many people, they're not going to go out and they don't need to get what they used to have, which was a prescription,
Right.
that they had to have a medical necessity, even though anybody could get this prescription card at will. But now people are just going to be smoking it. But again, if you have in your rental agreements a no smoking provision that your building is a smoke-free, which I definitely recommend everybody do, then you'll be able to prevent them from smoking because it just creates problems. Not necessarily if you have no problem with it as a landlord. The problem is other tenants in the building. People are very intolerant to smoke, rightfully, wrongfully, but that is what it is. Now, I have on my website also a change of terms of tenancy so that if you do have an existing tenant there, you can change the terms of the tenancy.
Not in a rent control jurisdiction.
Well, you can. You just can't use that to evict. So
it's a meaningless document.
Right, but it does at least give the landlord some teeth to say to the complaining tenant, look, I've served a notice, he's not supposed to do that, but unfortunately the city of Los Angeles has tied my hands and not allowed me to use Dennis Block to evict this tenant.
Will you put in your lease a provision that says no smoking of any kind? Would that be upheld in a court of law, regardless if it's tobacco or marijuana?
Well, my leases already say that. They say this is a
I
smoke-free
get
building.
it, but if you were to put in your lease, hypothetical, we specifically prohibit you from smoking marijuana on the premises, is that going to stand up in court?
I don't think it makes any difference between that statement and the statement of
Okay.
no smoking building. It's the same. People know what that is. Listen, there's e-cigarettes, there's all these vaporizers.
Hookahs.
Yes, I mean where
Which are running-
you don't have
which
to
are-
bother other people with this,
That's right.
and you can smoke your head off, but it's not going to bother anybody. But
E-cigarettes do produce a vapor that some consider bothersome.
possibly, but again, if you're not bothering anybody, feel free to do it. But the reality is that landlords need to protect themselves. They need to have these provisions in their rental agreement. Again, use my rental agreement or use my change of terms of tenancy, but that really needs to be in all of your rental agreements.
Okay, Dennis, I think that about wraps it up for.
It does?
It certainly does. We've been jawing for about 30 minutes, and you've got things to do, and so have I. So, why don't, as always, tell our listeners how to reach you.
Hey, I'm Dennis Block. If you need to reach me, I got a phone number right there. It's 1-800-77-EVICT. Or you can catch me, you're so nice. You can catch me on the internet at evict123.com. You can watch these podcasts here, or even on iTunes or any of the other podcast apps. And of course, I've got all of my forms on there. So, and once again, if you got any property in San Diego, we're open for business there.
And I'm Zachary Lawrence of Parkside Property Management, parkside123.com, saying so long. See you next time on the Landlord Tenant Radio podcast. Dennis Block.